Can you tell us, identify any two pillars of devolution in the Constitution and why you think they are important?
Okay. The first pillar of devolution is the right to govern yourselves, so that those who felt that they were marginalized can now say that we are running our own affairs. So that is one aspect of devolution, and it has some historical connotation. The other pillar is the distribution of our finances and the economy. So the distribution of wealth to cascade down to the world level is part of the devolution objective.
Okay, so having identified those two pillars, how has the Supreme Court supported those two pillars? And you can cite specific cases. And
there is the case of the Speaker of the Senate and others versus the National Assembly, where the Supreme Court was called upon to decide whether the Senate has an input in the division of revenue bill, which had been passed by Parliament. And the Supreme Court said yes, it's not that the Senate should wait for the division of finances amongst the counties, but it also has an input in the division of revenue bill. I think that is one aspect I can look at and say maybe that is the only case I can say.
Okay.
Yes.
Finally, international treaties, and we agree, international law is part of the law of Kenya. International treaties play an important role in protection of fundamental rights and freedoms. Can you tell us any African treaty that is applicable in Kenya that is important in terms of underpinning this Bill of Rights?
Okay, we have the African Charter for People and Human Rights, which was Kenya is part of it. So that one follows the International Covenant on Civil and Political Rights to some extent, but I think that the African Charter of People and Human Rights has some connotation of.
Okay. Yes. And what is the enforcement mechanism of that treaty? Briefly explain to us.
Okay, these treaties, states are called upon to comply with the provisions of those treaties, and the enforcement mechanism is by periodically reporting periodically reporting if you have assented to the treaty, so that you file periodic reports, just like the UN, you have to file your report on human rights, other civil liberties. So there are those periodic reports the state through in Kenya, the Office of the Attorney General. They file these yearly, either yearly or biannually. I am not so sure about that, but there are those reports. But there is also the court, like we have the court in Arusha. If in case there is anybody complaining, then that dispute can as well be another way of enforcing the law.
Any case of note concerning Kenya?
For Africa, I would look at the one which dealt with the decision of Honorable Martha Wangari, and then there is the one of those people who live in the forest, who went to that court, and Kenya was told that you have to leave, you have violated their rights.
Okay, thank you very much, and thank you, Chair.
Thank you very much, Honorable Judge Majaja. Thank you, Your Honor, I will now request Commissioner Macharia Jero to ask his questions. Commissioner.
Thank you, Chair. My Lord, just a few questions in view of the fact that we interacted more comprehensively in the last interview. Now, the first question. Next year we'll have an election, presidential election, and of course, if there's any matter to be decided regarding the election, it has to be at the Supreme Court, where you would be if you go there and become a judge. Now, we are alive to the fact that there's that tendency of the general madness that engulfs our country every time there's an election. Now, which leads me to the question, as judges in the Supreme Court, you being one of them, what do you think it would take not to be influenced by external factors, the prejudices, where you'll see that everybody becomes affiliated to a certain political thought. You are supporting a certain cause which could end up now influencing even the way one is taking a position in the Supreme Court, where you find that rather than providing guidance that is purely dealt with in terms of the law, facts, evidence, there are also that prejudice that could also come in among the judges when sometimes they bring in divisions even amongst them. Now, I'm not saying that has happened before, but I'm just putting that as a scenario. What is it that you would say it would take for judges to decide a matter, devoid of all these external influences?
The determination of a presidential election petition is a constitutional requirement under Article 140. So, not even an election petition. Every case, most of the cases have some external factors, external push. There are those for and there are those against. So, as an impartial arbiter, you are not saying you block your ears, but it's presumed that you are not hearing those factors. You are living in the community. You can open your WhatsApp. So and so is saying this, another one is saying that. But when it comes down to hearing and determining that case, what will be at play will be the documentation presented before the court. Note the stories you read in the newspapers. Note the views of people you are watching on the television. So even if people, the judges, everybody has his own opinion, not because he's a supporter of a certain political party, but it's because of his or her understanding of the case. So I don't think there is room to be influenced by external factors. We are there to dispense justice, and we will evaluate the case and do justice to that case.
Now, then, when it comes to the issue of external influences, now let's forget about the presidential election matters. Even in general disputes that would come there, where you could find that there are prejudices, maybe because of the way we've been brought up, probably because there are certain beliefs that one has. How do you marry that with when a matter comes where there could also be different positions that are taken by the different judges you'll be with in the same court? How do you marry that and ensure that at the end of the day, whatever ultimately is the basis on which a case is decided is not on these prejudices of the different judges who could be in the court?
That is in line with what Madam Chair, Commissioner asked, that now that you are there as a judge, how will you assist in handling some of those cases? Now you are putting me in a position where I can say so and so is prejudiced or biased towards this, but I don't think that would happen. If I'm there, all what you need to do is you have taken an oath to dispense justice. So dispensing justice means you are impartial and non-partisan. Being a judge of the Supreme Court, where the responsibility is much higher because the task at hand when it comes maybe to the presidential election or to even any matter which reaches that court, I would say that negotiation and trying to reach a unanimous decision without infringing on the views of others will be maybe the most important thing to do, at least to try to harmonize. But if somebody is of a contrary view, what is his position and why does he have that position? 1, 2, will also be guided by precedents. We have had several cases before that court, and we will see what the court has said in the past and try, although the court is not bound by its past decision, but we can see those cases as guiding aspects of determining future cases.
Mm-hmm. Now, the other thing is about the development of jurisprudence. Because you see, we are a country also, I think, based also on our training at the university and the law school, we have this tendency of relying heavily on common law. And of course, this common law, as we know it, was developed elsewhere. These are traditions and practices of another country. United Kingdom to be specific. Now again, when you come now to Supreme Court, you'll see that one of your requirements is so to develop our own jurisprudence, guided by our own traditions, our own practices, our unique circumstances. Now, I'm not sure whether that the Supreme Court has been able to realize so far. The jury is still out there. I'm not saying that they've not. But what role would you play in ensuring that even as we develop that jurisprudence, not that we'll ignore what has been decided elsewhere. We are, as legal practitioners, we are very good at quoting decisions from other jurisdictions. But what steps would you take, of course, in a collegial manner, to ensure that we have this jurisprudence in accordance with the expectations of the law that is also suitable to our circumstances, not relying on jurisprudence and circumstances of other jurisdictions?
Thank you, Commissioner. It's very rare to get a legal issue which has never been tackled in this world, that this is quite unique. Even if a case of COVID is filed today, it must have been filed elsewhere and a judgment or ruling rendered by another court. So we cannot operate like we're an island. So even the jurisprudence which we want to develop within our country, I'll give an example of the declaration that the mandatory death sentence is unconstitutional. If you read the Murwatetu case, the court elaborated other similar circumstances in Uganda, in other countries. So although we want to say we want to have a homebrewed jurisdiction, but to some extent you'll have to see what others have said. So if we are there as judges of the Supreme Court, it has been there for less than 10 years. When you talk of Marbury versus Madison, this is a case which is over 200 years old. So you cannot say that within 10 years we can pick and say this is the Supreme Court jurisprudence which has been developed within time. The common law we are talking about, how old is the common law? Many years. So my view is we have to give that court time and the jury out there is we want quick fix. So how do you develop jurisprudence within a short time? Jurisprudence is something which grows slowly as the cases emerge, and as they are developing the jurisprudence, there will be criticism. Maybe they will feel that the criticism is well-intentioned and veer towards another legal line. So by the time the court finds its direction, maybe it's 20 years. So let us give the court time. We are in a hurry to judge them. Or these judges, where is the jurisprudence? But the cases which have been taken there, they have handled them. They have given advisory opinions which have been useful to this country. They have handled 3 election petitions which form part of our jurisprudence. For instance, the standard of proof in election petitions. Although they came in with these not below balance of probability or not equal to beyond reasonable doubt, but that aspect has also been dealt with by other courts in India and other jurisdictions. So to develop your own homemade jurisdiction and say this is unique to Kenya, it will take time.
Okay. Now my last question, this is now nothing to do with the jurisprudence, is that there's no doubt, I must say, that you write very well. When you look at your decisions, very well researched, they've captured the legal authorities, the facts, evidence, and you're also bold. You've made decisions without fearing the criticism and all that, and you think well. Good material for Supreme Court. But now then the question would be that probably somebody would say that you need to wait a little bit longer. You are young, you give chances to others who have been there a little bit longer, probably move to the next level, Court of Appeal, and develop more jurisprudence then before you can take you to the Supreme Court. I don't know what would be your response to that in terms of, when you balance yourself. We are now dealing with practical issues here. Sometimes the commission, you must also be practical about dealing with the various, when we retreat to make those decisions of who we give, sometimes we look beyond that very sharp judge who is able to make very good decisions, but we say, agoje kidogo labda tutangalia maneno yake baadaye. I don't know what you would say about that. Thank you, Chair.
Okay, thank you, Commissioner. Now it goes back to the qualification. Have you done 15 years? Yes, I've done. Even the CJ can go there with, we can get a Chief Justice who is hardly 50. And because he graduated when he was 25, and he did 20 years of practice, he's 45. And he becomes a CJ. He comes here and impresses you. Won't you give him that position because of age? In fact, that will be discrimination if we are to follow the Constitution. That will be discrimination in form of age. Be that as it may, in America, they have 9 Supreme Court judges. I think there is one who is 48 years below my age. There is another one, I think, if my memory serves me well, called Neil Goodrich, something like that, who was born in 1967, like me. There is another one who is around 55. And then we have the old ones who are 82. Justice Clarence Thomas, I remember him when he was appointed, when he was serving. I had a lecturer from America, Justice Clarence Thomas, he used to be his critic. He's 72. So it's a blend. You can't say ngoja kidogo because you are 54. We will look at you when you reach 60. I have a classmate in the Supreme Court, and he has been there for 5 years.
Very well said with those examples, Honorable Judge. And I even thought, even in Kenya, Commissioner, we had a very young judge. Was it in the early years? Yes. It's now my honor to request the Attorney General, Commissioner Kariuki, to ask his questions.
Thank you, Madam Chair. Good morning again, Judge.
Good morning, Attorney General, Commissioner.
Let's just follow up on that last question of Honorable Commissioner Macharia. And you mentioned the US, and you're well aware of the contribution of the late Lady Justice Ruth Ginsburg. What special attribute, my Lord, particularly in terms of judicial philosophy, would you be bringing to the Supreme Court so as to shape its future?
Thank you, Commissioner. As judges are appointed to a court, most of them maybe have been having a certain aspect of saying, I'm aligned to women's rights, like the judge you are referring to, women's rights, civil liberties, and so forth. There are those ones who have a bias to criminal law and would like to deal with issues, to deal with the criminal justice system. So for me, for the specific question, for me, my jurisprudence will be based on the rule of law. Let the law be the supreme. Let the Constitution be interpreted widely so that it encompasses the rights as provided under the Bill of Rights. Let us not restrict the enjoyment of those rights as aspired by Kenyans. So the philosophy and jurisprudence on the aspect of constitutional law will be to ensure that rights should not be limited. I'll give an example. When I was in Malindi, there was a curfew which had served its purpose because of terror attacks there, and a petition was filed, and I think I declared the curfew to be not serving the purpose, and people want that freedom. We came from very far, so the fishermen cannot go to the sea because of this fear. Terrorist attacks, and now you limit yourself because of fearing him. So I felt that this is too much. Almost 6 months down the line, people of Lamu cannot go about their lives. I remember handling a murder case of a police officer who was manning a roadblock, and it was just 6, and a border passed very fast, and a lady who was the pillion passenger fell down and suffered brain damage, and she died. So with that in mind, is the curfew necessary after 6 months, like the case of Lamu? So my philosophy is, let us give the freedom to Kenyans. Let them enjoy the freedom as enshrined in the Constitution. Let us not put so many limitations, a lot of gabions and bottlenecks to Kenyans. Where the limitation is due, and there is a good reason for that, I would uphold it. But my philosophy is that Kenyans want this freedom of all the rights as provided in the Constitution, and if I'm there, I will strive to enhance that.
Thank you very much, my Lord. Let's move on to another aspect of collegiality. Would you agree that collegiality is particularly important in the Supreme Court? And if so, why?
First and foremost, I do agree that collegiality is very important. Why? Because it gives trust, that you trust the person seated either on your left or on your right. You are seated there as colleagues and you are doing the same work. All of you are there with the authority of Kenyans. So without collegiality, where you can stab your colleague at the back the moment he leaves, or you can rubbish whatever ruling he has written and say, Sasa huyu, what has he written? That I think damages the trust the Kenyans would have given to the judges. So collegiality is quite crucial in such a court. First and foremost, you are few. Unlike in the High Court where we are almost 100, the law provides that we can be 200. You may not have that close link to a colleague, but if you are 7, you are seated in the same area, going to court in a batch of 5, or even all of you 7, I think there is that need to know one another, to move together. It's a team. I would say it's like a netball team where you're a team of 7. So it's important, Commissioner, that the judges of the Supreme Court should embrace collegiality. You can have contrary views. Collegiality does not mean that all the judgments must be by unanimous decision. But even when you are disagreeing, you also respect those of contrary views, and without any finger pointing or shouting at each other, so that tomorrow, I've seen, like in the Supreme Court, I've seen one judge, like I've seen in the case of Rai, Justice Ibrahim dissenting. I've seen in another case, Justice Njoki and Ojwang dissenting. So I've seen Justice Lenaula dissenting, but so long as there is that collegiality, tomorrow will be called in another case and we have to handle it. So it's quite important.
Thank you, Judge. And how would you then balance in maintaining that collegiality on the one hand and the decisional independence of you as a judge of that court? How would you balance those two concepts?
Thank you, Commissioner. The balancing come in many aspects. First and foremost, don't have a fixed mind that I've read the file and this is my position. If you say that, and the other 6 also say that, whose position will be paramount. So there is that need of giving way and relooking into your position, also relooking into each other's positions, so that by the end of the day, you also understand where the others stand. Then that independence, because there is that aspect of not being influenced by colleagues, so that you can be independent. That's why now the dissenting opinion comes in when you think that, to me, this matter, the legal position, I've read other jurisdiction, I've read past decision, maybe from the High Court, which are convincing. Then you come up with your own decision, so that you don't just agree for the sake of saying it's a unanimous decision. There is that room for disagreement. So there is the need to balance where maybe there is doubt in your mind whether your position is the correct one, you can give in. But when your competencies and experience makes you to conclude that your position is the correct one, you stand by your position.
Thank you very much, my Lord. Finally, you've just used the word trust, and this came up earlier in the context of the vision of the court. The need for the public, for Kenyans to have faith and trust in the Supreme Court and indeed in the judiciary. Now, my Lord, in successive reports of Transparency International, The judiciary has been ranked as the most bribery-prone institution. Now, in that context, and with a view to enhancing the trust that the general public have in the Supreme Court, how would you, as a member of that court, seek to remedy that perception that the court is prone to bribery?
Thank you, Commissioner. The work of the judiciary, I don't think there will come a time when a survey will be done and Kenya say there is zero corruption in the judiciary. Why do I say that? It is because of the nature of the work. You deal with people's lives, the interests are so high, and the expectations from the public is also quite high. So, Transparency International, whatever they do, we cannot fault it. It is correct. Even the reports, we have had the Ringera reports, we have had the UCO reports, the aspect of corruption is also, we have had your report, we have had the aspect of corruption is there in the judiciary. So to be specific to the Supreme Court, I've not seen that report as given in relation to the Supreme Court what the percentages are. But if I were to be there, how to enhance the trust? First and foremost, to me, the moment a case delays, it raises suspicion. That is my main focus on this corruption. Because I don't think there is a case of a file not found in the Supreme Court. The delay in the Supreme Court is also not very much. But for me to enhance the trust is to ensure that we deliver justice as fast as possible. The Supreme Court is also meant to, one of the objectives is access to justice, to ensure that whatever justice is being cooked in the court is to some extent in line with the people's expectation. I know we are the experts who will be interpreting the Constitution, but we don't have to interpret it in such a way that even a layman would say, surely, well, this judge is bribed, or this was the correct way. So it calls for enhancing our competencies, understanding the expectations of the wananchi, transparency within the determination of the cases, and giving good reasons for what we do, so that people can reduce. I would say reduce. You cannot eliminate perception of corruption, and we cannot say that so and so is corrupt. If you are called upon and go to testify, you can't. So some of those aspects of corruption, the only way to me I can deal with is to clear any case which comes within a given time frame, well reasoned. Here you are. The winner will be happy. The loser will say, I think the judges were corrupted, but we cannot eliminate that.
Thank you very much, my Lord, for answering those questions.